Welcome back. Now we are going to turn to panel 4, where we are going to discuss about human rights defenders at risk. As I think we all agree, the human rights defenders active in the grassroots level are often the most vital link in the processes that lead to accountability for gross violations of basic rights. We are here to discuss about the reasons and what we can do for those risks. In this panel, the chair will be Ramón Muñoz Castro. He's a lawyer and a human rights lecturer. He founded and he's currently the director of the Red Internacional de Derechos Humanos based in Geneva. Ramón.
Thank you, Eduardo. Thank you very much, the Academy, for the invitation. A very pleasure for presentation for the panelists. Jude Reine Alpani Gansu, is true? Reine was appointed as just at the International Criminal Court for a term of 9 years. Prior to join the ICC, Youth Alpani Gansu in the African Commission on Human and People's Rights. She was a member of several United Nations commissions of inquiries of human rights violations and chaired the Joint Working Group on Special Procedures on the UN of the ACHPR. She was appointed a judge at the Permanent Court of Arbitration, co-author of several publications. She has been a professor at the University of Abomey, Kalbani in Benin. She holds a postgraduate degree for the University of Maastricht, at the Bhutan, as well as a university degree of common law from the University of Jean Moulin, Lyon, 3. She also obtained a master's degree in business law and judicial careers for the National University of Benin. Jonas Christoffersen. Dr. Jonas Christoffersen has served as executive director of Danish Institute for Human Rights. He holds a Master of Law degree from the University of Copenhagen and is an attorney of the Danish High Court. Dr. Christoffersen has held a research appointment at the University of Copenhagen, several acting judge of the Eastern High Court, and as a deputy judge of the Supreme Court of Denmark. Dr. Christoffersen wrote his doctoral thesis of the European Court of Human Rights and has otherside specialized in the national and international human rights. Daniel Holoy, Mexican, is a senior policy advisor of the law and policy program of the Amnesty International. Previously, he was the advocacy director of the Mexican Commission for the Defense and Promotion of Human Rights, a leading Mexican human rights organization in Mexico. Has served as human rights advisor for the youth-led organization Espolea. Mr. Holos was part of the civil society group to work together with the Mexican Congress in drafting the Mexican law for the protection of human rights defenders and journalists. He has also collaborated with different research projects in international human rights law and international relations at the Center for Research of Teaching of Economics. Mr. Holod held a BA in International Relations from Universidad Iberoamericana and master's degree in International Human Rights Law. This panel for the risk, the human rights defenders in risk, is in the context of the very hard situation in Latin America, Africa, Asia, to greatest number of attacks on persecution of human rights defenders are linked to the defense of natural resources, extractive multinational companies or agro-industrial companies. The issue of multinational corporations and the violation of human rights on their part, and the inability of the international community to control them, is the major concern of active civil society at the UN and in the affected countries. The UN has adopted non-binding declaration and principles such as the guideline principles of multinational enterprise and human rights. These no-binding instruments have no proved effective in stopping attacks and persecution of defenders and ensuring adequate protection by governments. In order to advance in the implementation of the Agenda 2030, it is necessary that the treaty that is being negotiated at the UN includes minimum rules that can be accepted by the states in which multinational companies have their headquarters. In the treaty negotiation process, the key issue is access to justice for victims of violations committed by the multinational companies. The protection measures and remedies and reparations shall be consulted and adapted to needs of the affected communities, as well as remedies and reparations. The norms, the laws of international criminal law will have to evolve to deal with new phenomena of human rights violations in a world with new global actors that have more power and influence than some of the states in which they act. The Human Rights Council, the special rapporteurs, and the working groups have an important role in the protection of human rights defenders. The communication addresses to states by them and the recommendations contained in their reports develop international standards. The situation of the defenders was never worse than it is now. International criminal law has to adapt to new phenomena in order to provide access to justice and remedies. Is the general context for the discussion. Now, Daniel, you.
Thank you very much, and thank you very much to the Academy for the invitation. I think it's great and it's very important to talk about human rights defenders in this context, as human rights defenders play a key role in upholding the principles of freedom, justice, and dignity that underpin the SDGs. And they have been key stakeholders in developing, promoting, and implementing the SDGs. Throughout the years, the work of so many human rights defenders has contributed as well to the direct realization of human rights, to the strengthening of the rule of law, and fostering sustainable development. And well, as you know, and as it is established in the UN Declaration on Human Rights Defenders, adopted by the UN General Assembly in 1998, a human rights defender is any person who individually or in association with others acts to defend or promote human rights at the national, regional, or international level. This is a very broad definition, and what this means is that human rights defenders come from every walk of life. Human rights defenders can be students, can be journalists, can be community leaders, can be lawyers, victims of abuse, their families, doctors, teachers, trade unionists. They can be anyone. But this very broad definition has also brought some problems in order when we want to seek accountability or understand what are the problems that human rights defenders are facing. And we see constantly that those who dare to make a stand for human rights and speak up against injustice are usually left behind, often without any effective protection. Today, we have seen with great concern how governments are failing not only to provide effective protection for human rights defenders at risk, but are actually adopting laws and practices that are making the work of human rights defenders even more difficult. From laws that are authorizing the use of force against peaceful protesters, or that authorize the mass surveillance, to banning access to foreign funding, for example, or that impose very difficult requirements for civil society organizations to register at the national level. The result is that the space for civil society in general, and in particular for organizations working on human rights, is increasingly shrinking. In the last 2 years alone, Amnesty International was able to identify at least 40 pieces of legislation around the world that interfere with the right to freedom of association and that hamper the work of civil society organizations. Moreover, human rights defenders and civil society organizations are constantly portrayed as criminals, as undesirables, as foreign agents, or as terrorists, and many times are painted as a threat for development and traditional values. Such labels are clearly deeply undermining and give a green light for further abuses. So in general, this lack of an enabling environment for human rights defenders puts them at higher risk. Based on information collected by a group of civil society organizations, it is estimated that since 1998, when the Declaration on Human Rights Defenders was adopted, around 3,500 human rights defenders have been killed. But I'm sure the true number is likely to be higher, mainly because of the failure of the authorities to properly register and prosecute these attacks. Amnesty International has been documenting the attacks on human rights defenders for decades, and it has been a very important focus of our work. And over the years, we have seen important patterns that are yet to be translated into effective policy to ensure a safe and enabling environment for human rights defenders. So I want to highlight quickly three main of these things that we have identified as patterns. So first I want to talk about who are the human rights defenders that are being attacked and what are the reasons that are leading to these attacks. Second, the need to incorporate better protection measures that would avoid reaching to the level of deadly attacks. And thirdly, which is, I think, where the SDG 16 comes most into play, the need to combat impunity and to ensure accountability for the threats and attacks against human rights defenders. So who are the human rights defenders under attack and why are they being attacked? The first important thing to note here is that the reasons behind the attacks are multiple and layered. Some people are attacked because of the work they do, while others are attacked for who they are. Others are attacked in context-specific situations, for example, in armed conflict or where the repression by the state is very high, or a combination of all these three factors. So many human rights defenders are attacked because they stand up to unjust laws and government practices or because they share information that stands in the middle of powerful interests. So journalists, media workers, bloggers that are focusing on exposing human rights abuses, including those who cover armed conflict, corruption, or organized crime, are facing particularly high levels of attacks. The Committee to Protect Journalists reported that 54 journalists were killed in 2018 alone, simply for doing their job. Countries torn apart by armed conflict have been particularly dangerous for journalists, including Syria, Yemen, and Iraq. Arrests and arbitrary detention of journalists merely for reporting on critical issues for the authorities have also been on the rise, including in countries like Turkey, Eritrea, and Nicaragua. Another group at risk for what they do are people defending human rights related to the land, territory, and the environment, mostly for standing up on the way of economic interest, as was mentioned. For example, indigenous peoples demanding access to their lands or demanding free, prior, and informed consent, or rural communities who are opposing their displacement from their lands because of the development of extracting industries like mining or hydroelectric projects. According to Global Witness, another civil society organization, more than 200 individuals were killed in 2017 for defending the environment. Countless more suffered threats, unjust prosecution, violence, and division within their communities. Amongst the deadliest countries for this group of human rights defenders, we find Brazil, Colombia, the Philippines, and Honduras. Human rights lawyers are another very particularly targeted group for defending human rights. Their work is fundamental in ensuring victims' access to justice and reparations, and this is what many times leads the attack against them. Many human rights lawyers are also facing reprisals simply for cooperating with international human rights mechanisms, or even with the ICC. Other justice sector workers, such as judges and prosecutors, are also being under attack, are suffering different types of pressure in efforts to undermine their impartiality or their independence. This includes direct intimidation to try to prevent them from bringing human rights violations to justice. In Honduras, for example, at least 117 law professionals were killed between 2010 and 2016. And recently, we have seen in Poland how judges that have upheld human rights through their sentences, have been threatened or even arbitrarily dismissed. The dangers human rights defenders face for their activities often intersect with the risks for who they are, for their identity. The different forms of discrimination that human rights defenders face overlaps and interact, intensifying the experience of risk that human rights defenders are facing. Women human rights defenders is a very clear example of this, who are often exposed to increased risk due to their gender, particularly when they publicly demand human rights that are challenging gender norms and gender stereotypes. They are also left open to specific forms of violence that other human rights defenders, that their male counterparts might not face. Many human rights defenders face also added pressure within their families and their communities, particularly when they challenge entrenched traditional or religious views. For example, in many parts of Latin America, where access to sexual and reproductive health and rights is severely restricted, we have documented how women defending such rights have been subjected to harassment, arbitrary detention, and unjust prosecution. In the US, healthcare providers, particularly those doctors who are providing abortion services, have been targeted with violent attacks for decades, including bombings and shootings outside their clinics. Human rights defenders who are sex workers or who defend the rights of sex workers are another very particular group at risk. Their human rights defense work is poorly recognized or actively undermined, both by officials and private actors, and they face violence and discrimination at the hands of clients, police, landlords, and the communities around them, as well as by exploitative third parties, including organized criminal gangs. As well, people defending the rights of lesbian, gay, bisexual, transgender, and intersex people are another group that are targeted for their identity. LGBTI defenders face great risks because their work challenges social structures and traditional practices. And as well, I already mentioned the fight of indigenous peoples and Afro-descendant communities who are struggling to uphold their right to live in their ancestral lands and the right to free, prior, and informed consent. These defenders are constantly exposed to pressure and attacks by the state, by businesses, and by other private actors. According to Global Witness, 40% of all human rights defenders that were killed in 2016 working on these issues around land and territory, 40% of them were indigenous peoples. And well, the third context I wanted to talk about was when they are targeted because of where they are, because of the context in which they are working. For example, armed conflict, post-conflict situation, or where widespread criminality. So working in armed conflict areas exposes human rights defenders to specific risks, as civilians are often targeted as part of strategies to instill fear and collective punishment. In some cases, it is even humanitarian assistance providers who are directly targeted. For example, since the civil war began in Syria, civil society and human rights defenders, including journalists and humanitarian and healthcare providers, have been persecuted and attacked. Several human rights defenders, including volunteers working with the White Helmets who are rescuing people who were after a bomb attack, have been forcibly disappeared, and their whereabouts remain unknown until today. And even after the official end of hostilities, human rights defenders can face several challenges as violence continues over the years. In Colombia, for example, despite the peace agreement was signed in 2016 with the FARC, in the first year after the signature, nearly 150 human rights defenders were killed, particularly social leaders and indigenous leaders. Organized crime poses another big risk for human rights defenders, as criminal groups often use violent means to impose their control over territories, and particularly as well when states rely on military approaches to public security. So for example, the military approach in Mexico to deal with drug trafficking and the heavy reliance on the military forces since 2016 has led to dozens, if not hundreds, of human rights defenders, journalists, and victims who are claiming their rights being killed. Similarly, human rights defenders and journalists documenting law enforcement abuses in the Philippines in the context of the anti-drug campaign have also faced huge harassment and intimidation campaigns, including explicit threats by the president himself. But none of these attacks come out of the blue. And this leads me to the second point I wanted to raise, because attacks are more often the culmination of an escalating pattern of threats, mere surveillance, and different types of persecution. And this is why it is so critical to think about prevention, because such escalation must be seen as a whole and assessed for the level of the threat that they pose for the individual human rights defenders. It is crucial to increase our thinking in how to better protect measures or to implement protective measures that are not only reactive, but that can actually stop the threat to culminate, particularly when they are deadly attacks. Public recognition by high-level officials and other public figures are crucial for preventing attacks. The general lack of acknowledgement and recognition of the legitimate work of human rights defenders, and in some cases even direct threats posed by high-level officials, increases the risks and are the backdrop against these attacks or where these attacks are happening. Moreover, it is crucial that high-level authorities condemn when human rights defenders are attacked in order to send a clear message that these violations are not tolerated and that those responsible are going to face justice. Preventive measures should also include programs to monitor the trends and patterns of attacks, to design public policies that can address the root causes that are putting human rights defenders at risk. And very quickly, lastly, the last point I wanted to talk about, just to say a few words on the need to address the almost absolute impunity in which threats and attacks against human rights defenders remain. When crimes are not investigated and punished, the level and risk for all human rights defenders increases. Sadly, most of these cases and attacks are not investigated and remain in impunity. Only a handful of those 3,500 killings that I mentioned in the beginning of my presentation have those responsible been identified and prosecuted. And very rarely have the intellectual authors of those attacks have been brought to justice. Many times the authorities are quick to say that the attack was part of common crime or to raise some private affairs of the defenders as justification of the attacks. Investigations of attacks rarely or all too often ignore the connection of the attack of the human rights defender with their human rights work, or rarely take into consideration who may benefit from the death of the defender. But I wanted to mention two recent examples of international mechanisms to investigate attacks on human rights defenders that have offered alternatives that I think should be further explored. Number one, the UN-led investigation into the killing of Saudi Arabian journalist Jamal Khashoggi, and also the creation of the group of international legal experts to independently assess the Honduran investigation into the killing of Berta Cáceres. Let me just finalize by saying that attacks against human rights defenders create a ripple effect that touches friends and families, other human rights defenders, and societies at large. The effects reach way beyond the individuals attacked and send a chilling effect that can deter many other human rights defenders from standing up against injustice. Another human rights defenders in this context that can also be intimidated and inhibited from carrying out their work, while we see this happening more and more, individuals and communities whose rights are being violated are left themselves voiceless and without someone to fight for their struggles. But I think increasing our efforts to recognize and protect human rights defenders, including more thinking around prevention and accountability, can also have a wave of positive impact, and exploring new ways of bringing justice and reparations for these attacks that have taken place is really crucial in advancing forward. Thank you very much.
Thank you, Daniel. Now, Rainey, please.
Thank you, Chairperson, to allow me to intervene in this debate. And the topic on which we have to speak in this panel is about human rights defenders at risk. I try to follow a little the presentation Daniel has put on the table, and I think that it is not necessary anymore to try to find a definition for who is a human right or not, what is their main activities, and also who are there. What I would like to say personally is to try to fix the subject within the African system. I know better than other things more. And I can say that in African system, the topic of human rights defenders came just after the UN Declaration on Human Rights Defender. In 1998, we call Conference of Joburg. It has been held in Johannesburg in South Africa. And so far, the African Commission tried to do the best to find the way to deal with some difficulties that people, human rights defenders, are facing within their work. We can say, following the explanation, Daniel's explanation, we can say that human rights defenders could be considered like the fourth power in a country. We have generally three powers: the legislative, executive, judiciary. But so far, we can consider also members of civil society like the fourth power, including human rights defenders, because they have something to do, mainly within development in the country, where we have a problem of justice, where we have problem of, I don't know, of politics and so on. So we always consider them like the fourth power in a country. Human rights defenders could be at risk at any moment. We find that they could be at risk during a conflict time, after conflict, before conflict, but also during what we can say relative peace time, because they are working hard on some system, and when they are not well understood, they could be at risk at any time. I will give you an example we got when I was in African Commission in DRC. There were a human rights defender we call Chebeya. Some people could know him. DRC was not in conflict at this time, but just because Chebeya was asking to political actors to pay for what they are doing, he has been killed. And until now, we cannot know he has killed these people. Another situation is in Uganda, in a peacetime, but because a young woman, human rights defenders, has been identified as LGBTI, she has been attacked in her room. Uganda was not in conflict at this time, but it has been attacked. So we can say that human rights defenders are not at risk when there is somewhere conflict and so on. They are always, according to me, they are always at risk. And the main issue we can talk about here is to find the way we can reduce this risk at any moment, after what Daniel has said here. And I can go also to some reports I have presented when I was in the African Commission, because according to the rule of procedure, we have to present reports each 6 months during our session. And during that time, we always find that human rights defenders were in difficulties. So the main problem we raise at this time is to try to find the way we can reduce these difficulties for them. I will not go into what is the topics in which they work, because we will spend more time. But just to say that within the African system, many communication, as he said, many resolution, many reports showed us that we have to do something for this, what we call in French, cible. And the issue remains entier, and our challenge now is to search how we can find, improve the situation of this population for allow them to work more than they are doing now. I try to say that we should find the way to strengthen synergy before human rights defenders themselves, firstly, but also synergy before human rights defenders and political actors, because mainly in our countries, the situation is dealing with political actors. And lastly, to find the way to strengthen the synergy between human rights defenders and also technical actors, technical partners, and so on, because they need them. They are not working to earn money, but they are just working because they like what they are doing. So they need to be supported by any partners who want to support them. So how to work to strengthen these types of synergy I just put on the table. It is my first proposal, but in 2009, we decided within the African system to organize a colloquium and to find how human rights defenders had worked at this moment from 1998 until 2009. And we call this colloquium Jobo plus 10. Which has been held in Uganda, in Kampala, in Uganda at this time. And we say how we can do to help these human rights defenders in their work. We say that we should put into place a strategy of networking. And within African system, we have at date a network in West Africa, a network in North Africa, a network in South Africa, and a network in Central Africa. And we say that it is not enough because they have to communicate as well between themselves. And we put into place the Pan-African network of human rights defenders, just to find the way to help them to work peacefully, to not work too much at risk, because when they are together, it's better for them, and when one of them has problem, all the networks which are in the ground can do something for them. Today, I can also ask to all of us here how we can continue to work and to help these people. I also think about how to develop some tools of communication for these human rights defenders. I know that sometimes we can say that we have newsletters, we have this, we have that, but it is not enough. We have to find the way to prepare and to build some tools, specific tools for them. I don't know how we can do, but one thing I know is until now, we have just a kind of small, a kind of new letters which can help them, but it is not enough. And finally, I say that sometimes we always are saying to human rights defenders, yes, you are at risk, and you also, you are not allowed to go into conflict, into open conflict with your partners, but you have to go. How you have to go? just by dialogue. Now, how we can do to allow the human rights defenders to continue to dialogue, for instance, with a government which want not to understand anything. That is also a problem I'm putting on the ground. And I think that my fellow participants here will try to help us to, we all know that human rights defenders are always at risk. The main issue today is to find the way to reduce the risk anytime they are working. And the dialogue is most important because state parties, the representative of state parties, it is my own experience, they don't always understand what human rights defender is. And they don't accept contradiction, they don't accept dialogue. Why it is important for us to dialogue with them? We should find the way to continue to dialogue with them and to put into place what we call the permanent dialogue between human rights defenders and mainly political actors. I will stay here and expecting that some question will come from the ground on which I could give mainly answers. Thank you.
Thank you. Thank you. Jonas, please.
Thank you, Chair. Thank you very much for the invitation to come here today in this historical room. I was very fascinated by the bench over here. I just read a book recently about Hans Frank, the Governor General of Poland, who was sitting right there and being hung in this building a few months after. So it's quite fascinating to be here for many reasons. I'm the director of Denmark's National Human Rights Institution, so I'm mainly interested in human rights, and I had a little bit of a difficulty in seeing why should we work on the SDGs. I mean, they're not really human rights, are they? But of course they turn out to be, and human rights actually can play a role in the implementation of the SDGs. One of the areas we can see the importance of human rights is that there is an indicator under Goal 16 on whether there is or is not an established national human rights institution compliant with the UN Paris principles. So basically, one indicator of having safe societies and just societies is, are there a fully functioning national human rights institution in all the given countries. But that's not really the subject of today. The subject of today is more the SDGs and international criminal law. And if we look at SDG 16, that talks about peaceful and inclusive societies, we can see the link quite easily to the Rome Statute that talks about these great crimes that can be committed to threat to peace, security, and well-being of the world. So they fit quite nicely together. Also, the Rome Statute talks about crimes that are widespread or systematic attack on the civilian population. That's, of course, a higher threshold than what we have under the SDGs. There's a target 1610 that talks about killing, kidnapping, enforced disappearances, arbitrary detention, torture of journalists, media personnel, trade unionists, and human rights advocates. So basically, target 1610 of the SDGs directly include attacks on human rights defenders as an indicator of the implementation of the SDGs. These are some of the words that we normally know from international criminal law, but what I want to talk about a little bit more is some of the human rights issues that are connected to human rights defenders. I often find that when we in human rights circles talk about human rights defenders, we talk about human rights defenders as some kind of special, particular species on this planet. Whereas in fact, we, and I include myself because national human rights institutions are considered human rights defenders, of course, a lot of it has to do with fundamental human rights that apply to everybody. So extrajudicial killing is, of course, an intrusion in the right to life that should be punished. We shouldn't have impunity. Kidnapping as a matter of security and liberty and so on. Enforced disappearances now has its own convention, but before that is fully implemented around the planet and ratified, we could talk about right to life, right to security, right to liberty, and so on. And then normally I would say, you can read the slide, but I don't know if you can all read and see it, so it's a little bit impolite to assume that people can all see and read it all, but also arbitrary detention is a matter of right to liberty. Fabricated accusations against human rights defenders is a matter of a right to a fair trial. Use of rape is, of course, a violation of the right not to be subject to degrading and inhuman treating, and so on. So there are a lot of basically ordinary human rights issues that protect human rights defenders. And they also protect environmentalist, natural resources defenders, or non-taxation defenders, and so on. So a lot of it is basically ordinary human rights that, of course, are more important to human rights defenders because they are sometimes more targeted than others because of the political nature of the work. But the reason why I was being invited was not to lay out this, which is quite simple, but I think sometimes just to remind us in the human rights community that sometimes we can invoke more clearly general human rights than talk about something special for human rights defenders. What I wanted to show you, and I apologize for the little bit, it might be difficult to see this slide, but what I had prepared, and we don't have access to the internet, this is why I'll do it this way, is two tools that we have developed at the Danish Institute for Human Rights to show the link between the SDGs and various aspects of the work of the human rights systems. When the SDGs were developed or adopted in September 15, we had staff at the Institute said that there must be a link between the SDGs and human rights. And they sat down on their, for that purpose, so designed behinds, basically manually linked the SDGs to various human rights instruments. That was quite labor intensive, and the product that came out of it was a very big Excel sheet that was very difficult to put into operation. So they thought, this doesn't really help a lot of people out there, so can we make this accessible to the outside world, to show the link between the SDGs and all the different human rights instruments? And they thought, I mean, Google, they can search in all the databases all over the place, so couldn't we search only in the human rights instruments? And they said, yeah, maybe we can, but we don't know how to do that. So they contacted a company called The Specialists that have hired people with autism and asked, can you do this algorithm? Can you take in one pool of data the SDGs, the targets, the goals, the targets, and the indicators, machine read them, and on the other hand, you have another pool of data, which is just all the human rights conventions. That's all. Only that little body of text, and then link them. And they found Jens Peter, who's about almost as tall as you are, very tall guy. He came into our office with a t-shirt and a big belly, and he hadn't really showered for a few days and stumbled around, and he has studied astrophysics, and he said, I can't explain how you can do it, but I can do it. And so here we go. So what you can do is, if you go over here to your left, you can search from goal to right, but you can also search from a right to a goal. So if you're interested in the rights to a child and say, how does that link up to the SDGs, you can just do it the other way around. Then I have put in a search on target goal 16 and target 1610, which I just mentioned. And basically, I hit search over here, and this is what comes out of it. So here you can see it has a reference to the Universal Declaration on Human Rights. What are the provisions in the Universal Declaration that could be relevant to targets 1610? The same with the ICCPR, and then it goes on in the next screen that you had to scroll down to see it all, and then you can click on them and see what is the text of these human rights instruments that link up to the SDGs. That was groundbreaking when that was made. But it was just basically an overall say, okay, now we can see that there's a link. So the next thought of creative, and I'm very proud that we did this at the Institute, and I feel I can brag about it because I had nothing to do with it. I didn't understand why they were doing it. I didn't know that they started doing it, but they did it, so I'm quite happy about that. The next, so and basically this part of it is is web-based, and you can see it has the different languages on top: English, French, Arabic, Chinese, Danish, Russian, and Spanish. So you can go into the different UN languages and find the documentation in those languages. And that webpage is called sdg.humanrights.dk. SDG Human Rights DK. DK for Denmark. Okay, this one is a different tool. Jens Peter, he turned out to be a guy who could do many things. So what we thought was, in practical terms, can we use the human rights treaty bodies and other mechanisms and the output of those different procedures more specifically to support and basically to argue more specifically on what should be done to implement the SDGs, and vice versa, of course. So we thought, why don't we get Jens Peter to machine read not only the SDGs, the treaties, the text themselves, but also the recommendations coming out of the treaty bodies. And there are only about 55,000 of them. So it shouldn't be too hard to just do that thing. And so he did. So I'll just give you an example. So what I've done here is to type in Venezuela, and I put in human rights defenders. And if you scroll down over here to the right, you could also find women and children and other groups. And on this one only, I would basically get all the human rights recommendations from the different parts of the UN system concerning human rights defenders and concerning Venezuela. So one example here is, it also has to do with gender equality and women. It's basically a recommendation of CEDAW from 2014, and you can read the text of the recommendation in the middle. Then you have some of the keywords and so on to the right, and then at the very right over here, you have basically the documents. You can just tap on the document and you get to the original documentation where we found the text. And then the next one was also on, I didn't put that in there, and I wanted to show you this one too, because that has to do with UPR. So there are basically a few quite similar recommendations coming out of the UPR process, and the first one was from Canada in 2011, and that was accepted by Venezuela. So that's a good example of basically finding an accepted recommendation of Venezuela, and you can say, okay, friends, you have accepted this UPR recommendation, you have received this other recommendation, maybe we should try to get to work on this and that issue. So basically, that is what the whole this system is about, what it can do. You could also, if you are interested in some of the different rights issues that I mentioned before, say maybe I'm interested not so much in human rights defenders, but for instance in extrajudicial killings. So have Venezuela gotten any recommendations from anybody concerning extrajudicial killing? You just put in extrajudicial. You could put in arbitrary detention, you can search on rape, you can search on whatever you want to search on. And basically find these human rights recommendations through this instrument. So where does that leave us? Basically, basically this leaves us, of course, with an idea supported by evidence that there's a quite close connection between the SDGs and the human rights treaties and the actual work on the ground. Well, maybe not so much on the ground in Geneva, New York, on the human rights instruments, but at least showing what is going on the ground through these instruments coming up in these different international fora. From international criminal law perspective, you might do research on this and can we see a progress in these areas? Could you maybe say, okay, we are seeing in these recommendations something going on in different countries, and maybe have that as a warning signal, or whatever way you might want to use these human rights recommendations in your practical work. Okay, so basically that's what I wanted to present to you. It's easily accessible for those who can see and read in different languages, and it's quite user-friendly when you go into it. It's very easy to use. I just popped into it yesterday and looked at it, and it's quite easy. Now, a few words then on the SDG and human rights. I think the hope, at least in many human rights circles, is that the political momentum behind the SDGs could translate into support for human rights. That because we have political momentum behind the SDGs, we would also have political momentum behind human rights. I think the whole negotiation process showed that would not necessarily be the case, the way human rights were basically pushed aside in the whole SDG negotiation process, and we had a little bit in there, and now we're trying to work to get it in there. So I think that the warning, I'm more on the concern side, namely that the SDGs will not revolutionize human rights protection. It's an instrument, we should use it, but we can't assume they will just in and automatically revolutionize and make our work much easier. I think maybe rather there's a risk that the focus on SDGs that are non-binding will undermine or may undermine the protection of human rights, that governments become more concerned with reaching some of the SDG targets than basically implementing and respecting the full body of human rights obligations. In any event, I think the task before us is basically to find a practical way to use the SDGs to protect human rights. And we have had examples of that this morning. And also the other way to use human rights to ring fence the work to implement the SDGs, so that basically that's the old human rights-based approach to development, that basically it becomes a human rights compliant promotion of the SDGs. I think that's our key task. And back to human rights defenders, again, there's a little bit of a tricky question. How do we protect the rights of human rights defenders? And we can maybe take that during the debate, and it's also subject to the next panel. But a lot of it has to do basically with general respect and enforcement of ordinary, basic human rights, and I mentioned some of them before. So it's basically, in many ways, it's simply hard and dirty human rights work to protect human rights defenders. And of course, the tricky part is that if those who have to do the work are targeted to all these violations, that's where we have kind of a catch-22. But that's simply the task before us, is to get out of that catch-22 of protecting the rights of people who don't have rights, or have rights but they have their rights violated. Thank you.
Thank you. We open the microphone to the participants. I have a question for you. You think, in your experience now, what is your opinion for this emerging phenomenon of the attack of the human rights defenders? I think if you have experience in the ICC, it's necessary developing the new standards and norms of the criminal law for protect the human rights defenders, or it's naive, it's a dream?
The question has been directed to me, but what I can say is that I don't know if at date there is a specific topics on human rights defenders within the ICC. I know just that human rights defenders included in civil society through the NGOs and so on can seize the ICC by communication, sending some complaint and so on, and asking that ICC should be seized for this situation in this country and so on. But specifically, the ICC has nothing to do with human rights defenders, while it is a judicial institution. But they can work on the ground to allow the ICC to find the best way to have proof and so on, work on this issue. You are talking about attack to the human rights defenders. Yes, attack could be individual, but it could be also collective. When it is collective, in such a situation, which is in the jurisdiction of the ICC, we can say that ICC will deal with this situation globally and consider these human rights defenders as victims and so on. But specifically, we cannot say that human rights defenders has a specific situation, a specific benefit from the ICC. I can say that if we want to talk about attack against the human rights defenders, we should go from national level, because they are always working at the national level, at regional level, before coming to international level. So the problem is localized at national level. And when there are such attacks, it's what I'm saying just now, it is most important for us to be aware about what could happen for human rights defenders on the ground. If we are not aware, there could be attack, but impunity will continue to be proceeded by, I don't know, because when we are talking about human rights violation, we have violation of human rights by political actors, but also by non-political actors on the ground. So we have to deal with the situation globally.
Thank you. Daniel, what concrete measures will you propose, or Amnesty propose, in order to deal effectively at a global level with the crimes, protect human rights defenders?
Well, I mean, for me, one specific gap that we see at the international level is sometimes the lack of legal recognition of the right to defend human rights. And I think the Declaration on HRDs was an amazing step forward. It provided this very broad definition that I was talking to, and it has disseminated in just 20 years the whole idea of human rights defenders and as key stakeholders in international law. However, we don't have any legally binding instrument to protect human rights defenders at the international level. I think there are interesting experiences and steps that have been taken. For example, some rulings by the Inter-American Court that have already recognized the right to defend human rights as somehow an autonomous right, and not only the compilation of other legally binding instruments that, I mean, we understand that the UN declaration as more that compilation or the facilitation of other legally binding obligations that were already in other instruments, put together in a way or articulated in a way that protect or facilitate the work of human rights defenders. But we don't have any instrument at the international level, both either recognizing the right to defend human rights or to impose obligations on states regarding human rights defenders. And that is not to dismiss, obviously, what Jonas was saying, that obviously human rights defenders are, as any other individual, recognized as individuals who have those rights. But I think it is important to recognize as well that the specific work that human rights defenders are carrying on is putting them at risk. So I guess that gap is important to be addressed.
Thank you. Last question for Jonas. The communication of Jonas, the communication of the rapporteurs of the working group of United Nations sent to the states, developed to the international standards. If you integrate in your page web the communications or no?
If
yes?
I mean, when we work in Denmark, we always include the work of all the different treaty bodies and the procedures and all the instruments that produce something of relevance to Denmark. So we always do that, and I think all national human rights institutions around the globe do that. That doesn't mean that it is always listened to, and it doesn't mean that we maybe are always 100% loyal to what comes out of the treaty bodies, because sometimes they do produce stuff that isn't of the highest quality, and the quality needed to persuade Danish politicians, civil service, judges, and others to do exactly what this treaty bodies thinks we should do. So our starting point at the Danish Institute is we look at it, we take it into consideration, and we use it when we think that it could help us in our cause to promote and protect human rights in Denmark. But sometimes I have to admit openly that sometimes we take part of the recommendations of the treaty bodies and kind of push them a little bit aside. So, okay, maybe that's going a little bit too far in our context, and then try to do something else. And there's always this pragmatic assessment of how far can you move. And I'm talking in a Danish context where the kind of human rights problems we are facing are very often, sometimes they are severe enough, but sometimes they are nitty-gritty legal niceties that we need to figure out how to solve. But the starting point, of course, is to look at all the products of the human rights instruments and take them into consideration, see how far can we advance them. And sometimes we have to turn our blind eye to some of it.
Thank you. Now, the question. Yes?
Thank you for your fascinating presentations. My name is Nick Ortiz. I'm from Leiden University. And as you discussed, human rights defenders have had to adapt themselves to security risks or increased security risks. They're also the first responders on the ground, right? And at a time where it's increasingly difficult to access the crime scene of international crimes for institutions like the ICC, my question is, they're working with different standards and with a different field. So how have they had, what kind of trouble have they had adapting themselves to working with ICL, with the International Criminal Court, particularly with regards to evidentiary standards or materials that they're submitting in Article 15 communications to the Office of the Prosecutor? Basically, I just want to know if they've had some difficulties with that, or if they've still approached it with, as a colleague of mine once put it, the human rights chip to ICL. Thank you.
Yes, Eduardo, after Rainer, we take for...
Thank you to the panelists for your contribution to this eminently important issue. And I think it is one of the issues where we have seen progress and where we can expect much more progress, because there are so many aspects to the defense of human rights defenders that I'm really hopeful that much can be done to improve the situation, but under certain conditions. If I may, just to offer some hypothesis. In my experience, I had 3 years working in the Colombian UN office of the High Commissioner, and we had to deal every day with persecution of human rights defenders. First thing, don't trust too much in technical advices. They are important, but they will not resolve the problem. The problem is political. You have to raise the political cost of persecuting human rights defenders on the national and on the international level. Second, over time, the targeted group among human rights defenders are shifting. In my time in the 90s, it was high-level human rights lawyers who were killed. None of them has been killed over the last 15 years in Colombia. Now the targeted groups are environmental fighters, small peasant leaders. So we have to make a context analysis to really understand what's going on and how and whom to protect. And second, certainly in the United Nations at least, there have been, and I think you didn't mention it, but there has been some progress in the sense that every department now has somebody responsible for protecting those people who, because of their connection with the United Nations, are in danger. So what you call the rapporteurs for reprisals. This is only part of the problem, and sometimes it's difficult to distinguish why is somebody persecuted, but it's an open door, and it has raised much sensibility in Geneva, at least. I don't know whether in New York also, about the necessity that do no harm was mentioned this morning. So when human rights special rapporteurs or other people do intervene in human rights issues, they have a responsibility to protect the people they are communicating with. Thank you.
Thank you. I'm Eduardo Toledo, Senior Legal Officer at the Nuremberg Principles Academy. I would like to ask 2 questions, and I thought that Rainer will raise this issue, but Judge Alapini-Gansu made a point on conflict or no conflict and human rights defenders. So I would like to think first on what is conflict. So then when and how we can identify the different types of conflict. Because Rainer, you work in a case in Argentina, the case of the enforced disappearance of Santiago Maldonado, who was a person who disappeared, and then he was found in a river, just because he was a human rights defender, fighting for land for the indigenous groups there. I think we can agree that Argentina is not a country in conflict, but we found little conflicts that affect human rights defenders. So I want to know first if anybody in the panel can help us to identify the different types of conflicts. And second, I would like to know if you can see any change in the future in the private sector in connection with the UN Agenda 2030.
Thank you. Philip Ambach from the ICC. I just had a very quick question. I think elements have already been given, but if you could focus for my benefit on what exactly have been the tangible effects for human rights defenders since the agenda was issued, so since 2015-16 until today. What tangible effects can you say that the SDGs have had on human rights defenders, be that positive or negative, if any? Thank you.
Thank you. Eduardo, you repeat the question for the Raine?
The last one.
Yes,
the last
of course.
one.
If you foresee any change in the policies of the private sector in general, companies especially, in connection with the UN Agenda 2030, if the 2030 agenda has push any change, or will push any change in connection with the human rights violation, of course, and especially in connection with human rights violation of human rights defenders?
I will start first. Firstly, when a colleague are asking the question, making the observation, I was thinking on something, mainly with the question of my colleague, which is in front of me, behind Philippe. You know, the issue of human rights is a difficult issue. And I can say that for all of us here that we could not speak about, we cannot make a statistic to find if the situation of human rights defenders is better or not, if they are facing no more difficulties. Why? Because I discovered that human rights issue is always going like what we call in French, en dents de scie. And it depends on the political situation, financial situation, economical situation in each country. So we cannot say that at a moment, at fix, there is some improvement of the situation. It is the activity itself, the essence of human rights defenders' activity, which is so difficult. It's why we have to pay tribute for human rights defenders. We have to pay more attention for them at any moment. And coming to your first observation, yes, you are asking what is a conflict. It is difficult to answer this question today because conflict, as you said, has many explanations. It could come in many situations. But what we can say generally is that human rights defenders could be at risk, but more be at risk when it is a situation and so on. If you say that in Argentina today there is conflict, you are right, because we have some elements which can show to us that there is conflict. But what I would like to highlight is that sometimes, without such a situation, human rights defenders is at risk. That is my position. Maybe my colleague will try to highlight it again, but it's just what I want to show to you, that they are in conflict. Daniel just now speaks about women rights defenders. We know that in the African context, women rights defenders are more at risk, even there is not conflict in their country. Just because of issue of cultural issue, environmental issue, and so on, they are more at risk than someone else. And is what I want to. You are asking also if we can find a tangible effect about the implementation of SGDS. You too, you ask the same question. For me, I'm a technical actor. I am always looking around what political actors have done, have wrote, and I am always following them. We are talking about Agenda 2030 within the UN system, and Africa also try to regionalize this politics and putting into place the 2063 agenda. We are following them, but what we have to do is not to be discouraged, but to continue to work with them, to continue to make the pressure, but not to create an open conflict, which will not help us for the development of our countries and the well-being of the population.
Well, just to say three brief reactions to some of the questions. I think to what Rainer was saying, I think that the context analysis is crucial. I think what we've seen, particularly in Latin America, where most of these laws for the protection of human rights defenders and protection mechanisms at the national level have been put in place. I think one of the main challenges we are facing now is, one, the political will. So it's not only about having the law or even having some infrastructure in place, but what is the real political will of those at the high level to really implement this and to change the narrative for human rights defenders, to see them as allies in advancing whatever public policies and priorities of the government, but also the SDGs, instead of the enemies who are just criticizing and obstructing the work of the government. I think that the other very important element of the context that needs to be taken into consideration that some discussions are starting now is how to translate those reactive protection measures that historically have been more focused on the individual to address collectives that are at risk. And that is crucial in Colombia, also in Mexico, or in general in Latin America, where now we're seeing that the number one group at risk are environmentalists or human rights defenders working on the land and the territory, many times indigenous peoples, Afro-descendant communities. So how do we frame protection measures in a collective way that take into consideration and address the complexities of how they understand themselves as a community and not just as individuals? With regards to the change in the private sector, I think it is impossible to think today of effective protection measures or to change the risk that human rights defenders are facing without thinking of the private sector. Again, going to Latin America, where I have more experience and where I've documented more cases, most of these cases against indigenous peoples, again, or environmentalists, are related with extractive projects from the private sector. Many times, businesses that are hiring private security companies to use force or to repel those protesters who are opposing the project, who are themselves behind the killings. I mean, that's the case of Berta Cáceres. And even going further, how do we investigate that collusion between the private sector and the authorities, which is many times hidden in there? And I think that's a very big question mark. But I think the business sector is also, or can play a very positive role in here. And we have seen, for example, tech companies playing this role in actually facilitating or promoting the work of human rights defenders. So, I mean, it's a different sector of the private sector, but I think that there is also a lot to be said about the positive influence that they can have. And very lastly, just to talk about the effects of SDGs, I mean, we haven't documented it, and I'm just like on top of my head, some things, and that perhaps I would pose it more than as questions and the things that we have seen. But I guess one important element would be is how do we use the SDGs to empower human rights defenders working on the different goals? So the women working on SDG on women equality or on access to health, for example. How can we as the international community provide those tools for those human rights defenders to use the SDGs, also to change the tone of the dialogue with the authorities? So to take it to a different level of the conversation, and as I was saying, see us as your allies, as your friends in promoting these goals that we all want to push in our countries, and not just as the obstacles.
Maybe just a few words on the role of national human rights institutions in this. As some of you may know, there is a global alliance of national human rights institutions. We are about 100 institutions worldwide, and I think about right now 70 of us are considered compliant with the UN Paris principles and act quite independently in many contexts. We met in Marrakesh in October and adopted a declaration on human rights defenders, basically agreeing that we should work more in the coming years on human rights defenders. We've been supported by the EU as a global network the last 5 years under an EU project that we at the Institute have managed, and now we're getting a second phase and that will also focus on human rights defenders. And I think the point you made early on context analysis is key to our work. And I think what we can do as independent public institutions is to look at our societies through human rights lenses and bring out the analysis, the human rights analysis of our own societies. So what we need to do at all the rights issues I mentioned is say, I mean, is there a policy issue behind this? Is the policy in our country basically human rights compliant or not? Do we have an issue at the level of regulation? Are the laws and rules and regulations in place or not? Is that why we have the problem? If the policy is okay, the regulations is okay, are they implemented? What happens on the ground? That's where the issues often are, but also sometimes at the policy level. And basically we monitor the whole situation in our societies, figure out what is going on the ground, and basically make a human rights evaluation. And I call that the prime model. I mean, it's a policy okay? Is the regulation okay? Is the implementation okay? Do we have monitoring in place? And is that evaluated then from a human rights perspective, and then giving advice? That's what we can do as national institutions, advise our governments on what should be done. And that analysis we basically have to do in all these issues. So enforced disappearances, extrajudicial killings, arbitrary detention, right to fair trial, freedom of assembly, association, expression, and what have you that could be relevant to protect people on the ground. What are the mechanisms, do they work, and all that. And we can, as national institutions, we can make that analysis, we can bring it forward, we can come with recommendations to our governments. We can make it known to the outside world through engagement with UN treaty bodies that this is the situation on the ground in our countries, and bring focus on it. And that is what many of us are doing, more or less systematically. Sometimes we pick out corners and so on. Sometimes we do it more broadly, make these analysis. So I think, I mean, basically the human rights instruments and having national institutions, to the extent that we actually have the resources to do our work and the ability to do it, we can actually make this work that can at least shed light on the issues and point to where the issues are. And then we need help from civil society, outside partners, international community, to push our government to do what has to be done to these complex questions. But I think the key I wanted to pick up on was basically context analysis. It's very specific. It's very different. It can be extremely challenging to do the work, and you can have changing circumstances politically in very short periods of time. But that doesn't take anything away from the fact that we as national human rights institutions can actually make a contribution to the protection of rights on the ground. And I think we have many examples of us doing it. And we don't have any examples of any of us doing it perfectly, because nobody's perfect.
Yeah, the question.
Thank you for some of the very valuable contributions. The SDG 16 speaks of access to justice, accountable institutions, and also the rule of law. Now, if within the context of particular countries, if the basic institutions that are supposed to uphold the rule of law, access to justice and the rest, are themselves being undermined and attacked, have you considered defending them as the defense of human rights defenders? From the perspective of defending human rights defenders, by defending the mechanisms and those who uphold those mechanisms in order that the others can function in that environment. This is my first question. Second question is particularly relating to the national institutions. Some 15 or years back, there was a shift towards encouraging national institutions. national institutions are, as one of the researchers of the Danish Institute has written, basically ombudsman institutions. That to see that the rest of the mechanisms, where are the defects and how to recommend corrections. But if the fundamental mechanisms fail, fundamental mechanisms of the justice fails, was it a correct decision to put resources and put a lot of emphasis on these national institutions, particularly I'm talking with the experience of Asia, none of which have worked effectively. By their definition, they cannot work effectively because the fundamental institutions have failed. And these are a peripheral institution. National institution is basically a peripheral institution. Even when there is a goodwill and you appoint the right people, but the right people in a wrong place, they get frustrated. They cannot do it. So the very question of where should the main resources go, is it to uphold the mechanisms that uphold justice, that is, the investigative mechanisms in the state, prosecutorial mechanisms in the state, and the judicial mechanisms. How much of thought and things like that has happened in the international community in terms of domestic institutions of justice?
Thank you. We have 5 minutes if you want to. Yes, this one.
Yes, thank you. I think it's very, very important, and I totally agree that there needs to be more development and more talking about understanding judges and lawyers, well, lawyers more clear, but judges and prosecutors as human rights defenders. And I think, as I was saying, the UN Declaration on Human Rights Defenders is so broad that obviously it includes judges and prosecutors, and obviously they are key actors in providing remedy, access to justice, which are key human rights. Just 2 examples that come to my mind where we have seen these attacks very recently, and at least at the beginning, some shy responses from the international community. The example of Poland, where including the president of the Supreme Court has been threatened for challenging a law proposed by the president to undermine the independence of the judiciary. So she found herself hiddenly or subtly dismissed by a reform that reduced the age of retirement of judges. So by this law, they would be sacking a big proportion of the judges at the Supreme Court and at the federal level, who were particularly the most critical of the government. I think we need to analyze this as well as threats and attacks on human rights defenders, and then we pose ourselves the question, how can we use the international framework for the protection of human rights defenders to be applicable to these actors? Similar, the example of Guatemala, where we have seen very recently the constant attacks against the CICIG, the international mechanism against impunity, that has been crucial in investigating and prosecuting crimes of corruption, but also of emblematic human rights violations. And in the past 2 or 3 years, the attacks even by the president himself has led to they tried to withdraw every resources. They withdrew the visa from even the major prosecutor and many other people like staff working in there. So how do we understand these attacks as well as human rights defenders? I think it's an important question. And I guess very, very, very quickly, the last comment that I had is also how do we build specific tools for the judicial system to uphold the protection of human rights defenders? So beyond the normal accountability and prosecuting these attacks, which is crucial, as I was saying, what other tools can we provide to them? So for example, protection laws that now are being adopted in many countries. I think it's an important tool both for identifying the specific legal framework that would be conducive for the work of HRDs, but also as part of the recognition of that is required for human rights defenders. But also perhaps starting to think about special prosecutors to investigate and prosecute attacks against human rights defenders. So some countries are already putting in place a special agency within the prosecution authorities, or to develop special protocols for the investigations of these crimes. So for example, to ensure that those who are investigating these attacks cannot so easily ignore the fact that the attack was connected with the work as human rights defenders. So I guess that's, I mean, more ideas for moving forward towards justice and accountability.
No, I just want to say that about the issues of access to justice, rule of law, accountability you just talked about, we have there many most important issue. If we take just access to justice, it's so difficult to try to highlight this issue, while I thinking, for instance, that in a country, we have everything. We have judges, we have lawyers, we have justice workers, and so on. And but at the end of the day, the judges are not independent. Can we talk about access to justice for the population? While you know that even you go before the judges, you cannot find the best way to seek justice and to get justice. That is also a question I'm asking by myself. And I'm saying that it is quite difficult question you have posed. And I am attempting to say no to your question, and to say that at this point specifically, human rights defenders have much to do. The second issue about national institution, you are right when you are asking such a question, but I know that within the African system today, we have what we call within the African Commission strategy, how to give to national institutions the statute of affiliation, to allow them to duplicate on the ground everything concerning the African Commission, and to give this statute to the national institution. They have to deal with Paris principles. So I think that is most important also to find the way to do. But one thing is that we have national institutions, we have any institution when political actors don't want to deal with, to respect their own engagement, we will continue to have human rights defenders on the ground.
Also, just briefly on the impact on the ground of national human rights institutions, I think we have to be realistic and say you cannot expect wonders of political wonders created by non-political institutions. I mean, there's simply limits to what impact a judicial and independent public institution can have in a political context. And I don't think it's an either-or, that you either don't support the institution or support somebody else. I think you have to support the national institution and other institutions at the same time. And of course, there's difference between the independence that I enjoy in my everyday life, in a highly developed rule of law democracy in Northern Europe, where many things are at a level that a lot of people on the planet would want, and the independence on the ground in some of these conflict countries that some of my colleagues are working in. Of course it's different, but you have to be realistic and put expectations at a reasonable level. And do we have examples of protecting public institutions against human rights defenders? Yes, I did it last week or 2 weeks ago. We had riots in the street. We have basically a Islamophobic fascist running for parliament now in Denmark. He's become known in Denmark because he's burning the Quran in the street. That's blasphemy. But we lifted the prohibition against blasphemy, so it's basically exercising legally his right to freedom of association, assembly, and expression under Danish law. He has the right to freedom of assembly. It cannot be restricted under the Constitution, and we had these riots in the street. And people were saying that the police was racist because they protected him. Under our strange Constitution, they had to protect him. That's the constitutional right in Denmark for him to demonstrate and to do that. And I basically had to say, no, we can't complain, we can't say that the police is racist because they're supporting the rights of a racist. He has rights like anybody else, and we should meet him with words and counter it and all that, but we can't go against the police because they're doing their duty. So sometimes it's not so much fun to be a human rights defender when the rights of when you have to defend the rights of racist, Islamophobic fools and morons in the streets of Copenhagen, but that's also part of the job.
I think I finished now. No?